The floor is yours.
Thank you, Lindsay. Good afternoon. I'm here from Oregon. My name is Erin Lageson, and I am the presiding judge of Department 3 of the Oregon Court of Appeals. My fellow judges will introduce themselves.
Good afternoon, everyone. My name is Steve Dewitt. I'm a county court judge in the Ninth Judicial Circuit of Florida in Orlando, Orange County.
Good afternoon. My name is Doreen Hartwell, and I'm an attorney in Las Vegas, Nevada.
All right, students, would you please introduce yourselves?
Nice to meet you. I'm Aubrey Cooper.
I'm Isabel Cleland.
I'm Hannah Sullivan.
And I'm Medora Perkins, and we're Unit 5 from Sheridan, Wyoming, here with our mentors Kim Ferguson and Michael Thomas.
Great. Well, let's proceed. We are doing question 1 today. That question is as follows. As a result of the decision in Wisconsin versus Yoder, is that, quote, any parent/guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs, unquote. Do you agree or disagree with this result of the decision? Why or why not? What words, if any, are found in the U.S. Constitution or in state constitutions that protect the right to an education? And finally, how have courts balanced religious beliefs with other rights? The floor is yours.
Thomas Paine once voiced that spiritual freedom is the root of political liberty. As the union between spiritual freedom and political liberty is nearly inseparable, it's our duty to defend both.
In doing so, Paine emphasized the importance of our Constitution's First Amendment.
Our panel concurs with the ruling in Wisconsin v. Yoder, which preserves the right to religious freedom in America.
To elaborate, Article 6 of the Constitution dictates federal superiority, affirming that this Constitution and the laws of the United States shall be the supreme law of the land. Due to this, the decision of the Supreme Court in Wisconsin versus Yoder carries greater value than any state education laws.
Rulings in both McCullough v. Maryland and Engle v. Vitale illustrates the dominance the Supremacy Clause has over state and local laws.
Yoder's defense attorney, William B. Ball, argued that no one else's rights are harmed by virtue of Amish non-attendance.
His words outline that religious beliefs not harming others or jeopardizing the common good remain protected by the First Amendment. Samuel Adams proclaimed, "If virtue and knowledge are diffused among the people, they will never be enslaved, and this will be their great security."
In appearance, the United States Constitution lacks the explicit right to education.
Nevertheless, the federal government has passed a number of acts and created committees to encourage, fund, and organize public education within the 50 states.
For example, the creation of the National Institute of Education and the passing of the Equal Education Opportunities Act of 1974 provide a legal basis for the right to education in America. Continuously, the 10th Amendment declares that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people.
Therefore, education, unmentioned in the Constitution, is an issue to be regulated by the states.
For example, Wyoming State Constitution proclaims, the right of the citizens to opportunities for education should have practical recognition. The legislator shall suitably encourage means and agencies calculated to advance the sciences and liberal arts.
22 states, including North Carolina, California, and Montana, have also explicitly stated the right to education in their state constitutions. Brown v. Board of Education established every child's equal opportunity for education, and Kentucky's Rose v. Council for Better Education set precedent for several other states to establish a clear right to education.
However, rights are relative, not absolute, as seen in the selective manner of the Supreme Court of the United States when presented with a religious case.
Simply put, you are allowed to live and behave according to your conscience instead of beliefs until the social contract is broken.
Cases like Burwell v. Hobby Lobby and Masterpiece Cake Shop versus CCRC demonstrates the protections of free exercise of religion. Moreover, the Supreme Court created the Lemon coercion, endorsement, and neutrality test to aid in the interpretation of the Establishment Clause.
For example, one of the 3 prongs used in the Lemon v. Kurtzman regulates government legislation with religion, stating the statute must not result in an excessive government entanglement with religion.
Furthermore, the ruling in West Virginia State Board of Education v. Barnett dictates that students are not bound to compulsory school activities, such as the Pledge of Allegiance, if they violate a student's religion.
In continuation, Good News Club v. Milford Central School set precedent for religious clubs in schools like FCA, a high school club for Christian athletes. Both illustrate an emphasis on the social ideas
freedom of choice of religion where it does not directly harm another party.
In addition, defense attorney Leo Pfeffer in Docasso v. Watkins elaborated that the qualification of adherence to religion as a qualification for public office is the inescapable stamp of establishment of religion.
Supported by the unanimous decision for Docasso, the Establishment Clause stands for the religious beliefs but does not adhere to unconstitutional religious practices.
Ultimately, Joseph Kennedy III expressed this idea of a just balance when he stated, "There is a difference between exercising religious beliefs and imposing them on others. Our Constitution fiercely protects the former and expressly prohibits the latter."
We are now ready to take your questions.
What does separation of church and state mean in the context of religion and a right to education?
In the case of Lemon v. Kurtzman, there was they defined the right, the division between church and the government and state and religion using the three-pronged test, and this made sure that the laws that passed for education had a secular purpose, that education did not use means of funding for religious purposes.
This can be seen in Everson v. Board of Education, where they talked about state funding money for reimbursement towards all students.
Okay, what are the advantages and disadvantages of having an establishment clause or an established religion, excuse me?
I think the importance of the Establishment Clause in the First Amendment is extremely important because, as we see in our history, a lot of people came over to the United States seeking freedom from religious persecution. So when the founders decided to prioritize religious freedom in America, they made sure that it's a negative right that can't be infringed upon by the government, which is super important because of the diversity we have in religion in the United States.
I also think that there's an importance outlined in Reynolds v. United States and Braunfeld v. Brown, where they outline there's a difference between limiting someone's belief and someone's practice, so that our government is not allowed to, they don't limit the belief of a religion, but they do limit the practices.
Well, let me follow up on that. In Wisconsin versus Yoder, aren't they limiting the practice by saying, it's okay that they can leave school?
I don't believe they're limiting the religious practice because they are allowing that student to be removed from school. However, an example of limiting practice can be seen in Employment Division B. Smith, where an employee decided to use peyote and for religious purposes, and the company pressed charges because they did not permit that use of drugs in their company.
You mentioned in your prepared remarks that 22 state constitutions protect the right to education in some way. If an individual student in one of those states thought that they weren't getting the education protected by the Constitution, how would they go about enforcing that right?
I think, as seen in Wisconsin v. Yoder, they can press charges against the school and the state because the state under the Every Child Succeeds Act are forced to provide everyone the right to education, even illegal aliens, as seen in Pyler v. Doe, and students with disabilities. So a student, if they feel as though they're not receiving the education they should be, are allowed to take that up with the district and then the state if that's not being met.
In your prepared remarks, you mentioned or you emphasize freedom of choice of religion when it does not harm another party. What about in the case of mandatory vaccinations and to the extent that it's against an individual's religious beliefs? What's your view on whether or not that would be enforceable or constitutional?
An example of this is I know that our school district, the Sheridan County School District, that we have required vaccines for our school for students that to be able to go and get an education. But there are religious exemptions from those vaccines because you still have to provide an education for everyone, especially outlined by that, as my colleague mentioned, Plyer v. Doe, which says you have to give an education to everyone. So there are religious exemptions towards vaccines, especially when you, in the case Jacobson v. Massachusetts, where the courts ruled that the states can enforce a vaccine if it is protecting the common good.
Continuously going off of what my colleague said, we believe as a panel that the freedom from compulsion is very important. So seen with the COVID mandates for quarantining people in Cuomo v. Roman Diocese of New York, they ruled that the religious practices couldn't be limited, so the church was still allowed to meet. So we think that because the Supreme Court has chosen to prioritize religion over potentially the common good or like mandates, we believe that the vaccine could be an infringement upon personal liberties.
Well, how should a student's right to an education be weighed against a parent's, a right to impose their religious beliefs? And in particular, in this situation, in the Yoder situation, where the parents who were Amish decided they didn't want their kids to go to school after they were 16. What if the child wanted to go to school? How would you feel about that?
As a minor, we are not, we don't have full constitutional rights, so therefore we have to comply to what our parents are forcing us to do. However, in the case of Amish parenting, they also allow for their children to go out on sprees when they're around 18 to kind of discover themselves and decide if they really want to choose to live an Amish lifestyle or go out into the world.
And that was outlined in the dissenting opinion of Wisconsin v. Yoder, that the children under 18, that we didn't have full constitutional rights, and the parents still had that control over us, and that's what their parents wanted for their children, and that was following their religious beliefs, and that the child still may not want to follow under those same religious beliefs, but the parents' religious beliefs has a more dominant role.
And referenced in our essay, no one was harmed by the Amish's non-attendance to school.
You mentioned the Cuomo, the Archdiocese case just a minute ago, and stated that you as a panel agree with what the majority of the Supreme Court said in that case. What were the competing opinions in that case, and how did the different justices view the issue differently?
I think it can definitely be seen that having those religious people meet in one spot, especially during this time of COVID vaccine, that it is harming our common good, especially as the pandemic grew. But people were arguing that it was limiting their religious practice, and that the government does not have the power to limit their religious practice, even though it may have been harming the common good.
So going off of that, I think what my colleague was trying to say is that the dissenting opinions...
It is time. We could talk with you for so much longer, though. Wonderful job. So thank you for your presentation. I really enjoyed hearing it, listening to it. You have a really wide-ranging discussion of the case law, which I appreciated, and I appreciated how you included it both in your prepared remarks, and then were able to, in responding to our questions, pull the cases out of your brains and articulate the cases that were relevant in supplying the answer. I appreciate your engagement with what I think were some pretty tough questions. What else? Yep, that's what I've got. Very good job.
Thank you.
Thank you.
Thank you.
Yeah, I thought you guys did a great job. You really answered the question. You took a side and you stuck with it, and you provided evidence to support your position. And while acknowledging that there is another viewpoint, you stuck to your guns. I thought that was great. I loved with regards to your prepared remarks. You incorporated, the historical aspect, the Constitution, case law. You covered pretty much everything. You had some different federal statutes that you referenced. Like my colleague said, it was just such a wide range. You covered such a wide range of issues in law with regards to your responses. You answered all of the questions that were asked of you. You were responsive to everything asked, and I like that you referenced the and I'm not sure which person actually did the dissenting opinion with regards to Yoder. I don't think that we've heard that yet today, and it was just I thought well done, very thoughtful responses and well done.
Thank you very much.
Thank you.
Thank you.
Yeah, that was very fun. I enjoy it when it's a conversation, and I felt like it was a bit of a conversation. The time went by too quickly. I didn't have an opportunity. I had another question I wanted to stick in there, and I just didn't have the opportunity. And so that was great. You also, I did one of the notes I have here. I wrote down dissent and circled that. That means a lot to me because a lot of people, and you guys are, me or kids. You are kids. I'm an old man. And certainly not ones who've gone to law school. I don't think you've gone to law school. You don't look old enough. But
No.
there are the younger people, and this happens with lawyers that appear in front of me. They have a tendency to read the head notes, what's called the head notes of the case. The very beginning, where there's those little notches and it has a number next to it, and you go to the case. They read that, and then they think they know what the case says. They don't bother reading the whole case, and they come up and they argue the case in front of me for an emotion or something. And I go, well, what about the facts here? This doesn't apply. And they deer in the headlights. They don't understand it. You don't do that. Not only are you not a head note reader, you read the whole thing, you digested the thing, and you read the darn dissent and threw that back at us. That's fantastic. That is really, really understanding and looking at the case. And then what you did with that was you said in the dissent, and you took what the judge said in the dissent, put it back on what the question was. That was really well done. You also mentioned the Rumspringa, which is, that was in there. That's not something that a lot of people, first of all, even have any knowledge of. So the fact that you got that out of the case is great, because really that is the crux of that case. It's not about that the parents can just take out their children and do what they want willy-nilly. They decided this on a very narrow issue. That is that these kids that are from this Amish community are not, or they don't need this education. To me, it's really not so much about the whole ending of the Amish, old Amish traditions, which they talk a lot about in the case. It's really about the fact that these people are going to be farmers, and they don't need to go to school and learn this extra stuff. That's part of the argument. But you guys got that. You laid that out there. So it was fantastic. Good job. I really enjoyed it. Thank you very much.
Thank you for your
Thank you.
feedback.
Thank you.